that event, you can understand that your job will be over. You would have demonstrated to the examiner that you completely in control of the medium that you are using, and there is no way the examiner will not appreciate that answer, because the answer is short. It is not, you are not going to be evaluated on the length of the answer. The accuracy of your grounds is important. It may not be conclusive, because in the drafting paper, the examiners do not always look at the legal substance of what you have said, but it is looking more to see whether the formatting is correct, whether the concept is correct, whether the basic structure of what you have done is correct. So, if you say that something is violative of Article 14 of the Constitution, it may not be so. An examiner may disagree with you that it is violative of Article 14 of the Constitution, but the examiner will certainly mark you, give you the marks, because you have raised a ground in the proper format. But raise the ground and put it down in 2 sentences. Do not labor on a long answer. It is not necessary, it is not going to be helpful, it is going to cut short any other answer that you are going to give. Along with this, one aspect which I always emphasize for all examinees, and this has been the position all along, is that, and you can understand this very clearly, each question has a certain number of marks, let us say 20. If you do not attempt it, you cannot be given a single mark in that answer. Whereas if you attempt it, even if it is short, you will be given substantial marks if your answer is very good, even though concise. You will certainly get some marks, even if it is not concise. So therefore, omitting an answer is far worse than writing 6 short answers. So, this is the second aspect that I need to emphasize in every such session that I have addressed examinees. Complete the paper, do not leave questions unanswered, because answering a question will get you marks, not answering the question loses all 20 marks. The aspect which is connected with this point that I am making, that you must complete the paper, is that if you ever get stuck in the last answer, then suppose you have 3 to 4 minutes to do one draft. Then quickly sketch the draft instead of getting into long details of it, or starting with long details and then having to stop whatever the time there is, 2-3 minutes. If you in that 2-3 minutes give the parties, give the body at least 2 or 3 lines each and give the prayer, you can understand that you will be marked more than if you had only given the parties in detail. So these are absolutely practical aspects that I am emphasizing today in this program. Now, how do we go about drafting anything? We first, number one, we have to marshal the facts. That's always the first step in any draft. The marshalling of facts means any fact which is given to you in the question paper. For this purpose, you can either make a rough note somewhere, or you can start by writing out the list of dates. That is enough to get complete control over the facts. Marshalling of facts is best done chronologically. In fact, inevitably it is better to do it chronologically, because when you maintain the chronology, the pattern emerges from it. Strictly chronologically, because then the patterns between the facts emerge, which would otherwise go unnoticed. You put 2 facts side by side in a chronological fashion, you understand their correlation. If you put them in a jumbled up fashion, you do not understand their correlation. So therefore, if you marshal the facts, the best thing to do is to marshal it in a chronological fashion. And a chronological list must always be strictly chronological. Nothing like in the meantime. So in 1919 such and such thing has happened. In 1999 something has happened. Next 2000 this has happened. Next in between this has happened. The chronology is lost. Now this happens repeatedly in our special leave petitions. Facts are not presented chronologically, and therefore the connection between the facts and what springs from that does not become apparent. Now sometimes it is done because you are uncomfortable with putting facts chronologically, but there is no point. It is much better for you from a practical point of view, not an examination point of view only. It is better for you to notice the pattern which is contrary to your, which may be against your interest, and somehow deal with it in the process, that is to neutralize it as we call it, than to leave it unanswered. So, when we teach advocacy, we sometimes classify all facts into good facts and bad facts. Good facts are those facts which are in your favor and which you have to portray before the court. The bad facts are those facts which are not in your favor. The strategy here is not to suppress those because they're going to come out. The other side will bring it out. But to neutralize them. If there is something to be said about it, then that is how you go about it. So there is some date, some fact which is a little against the run of play, if we put it, now that we are all watching World Cup. It is against the run of play, but you have an explanation as to it. So you are saying that this happened, but this happened because of this. So you have dealt with the issue. Strict chronology is what is always recommended. And by the way, you will find that in the Commercial Courts Act, these best practices, as we call it, these best practices have found their way into the legislation. Because in the Commercial Courts Act, it is actually stated in the legislation and in the appendix to the legislation, which is a modification of the existing Civil Procedure Code for the purpose of commercial suits. It is stated there that facts are best stated chronology. It is one of those best practices which are now incorporated in our legislation. The second aspect of any pleading is to figure out the cause of action. The cause of action has always been defined to be that bundle of facts which taken together entitle you to the relief that you are asking for. Now, this cause of action, which is, I call it a black box. It is that black box through which the facts enter and from which the relief flows out. That's a picture that I am keeping in my head. It's a black box. This is what a lawyer supplies. This is what the litigant will never have. The litigant has the facts. He knows what he wants by way of relief. He does not know how to go from the facts to the relief. You have to supply it. Because if you also don't know how to go from the facts to the relief, then you haven't provided the cause of action and your draft is therefore incomplete in a legal sense. So it's not enough that XYZ facts have happened and therefore I want this. It must be taken through the sieve of cause of action, and through that the relief becomes apparent. Sometimes this bundle of facts or the cause of action is a statutory cause of action. Statutory cause of action can be the specific relief act. It tells you the circumstances under which, if you have these facts, you are entitled to specific performance of a contract. If you don't have those facts, then if you have some other set of facts, then it may be enough for the purpose of getting damages. but it is not enough for the purpose of getting specific performance. So some of them are taken from statutes. Others are taken from the common law. That is to say, the law as it has developed through judgments over the years, over the decades, over the centuries even. When you are pleading, it is therefore important to use the precise language of the statute or the judgments which have created this cause of action. Now here I make a point which I always want everybody to appreciate, and that is writing a draft, or making a draft I should say, is not like writing an essay. It is not about expressing your emotions. It's not about being flowery or being lucid or etc., anything like that. It is a technical exercise. It's a technical exercise. Certain words have to be used and other words do not need to be used, and therefore they should not be used because it has to be short. So the precise language of the statute or the precise language of a judgment is the best way to plead anything. This requires practice. Obviously, you will not be able to do that just like that in an exam situation. But to give you an example, under the old Specific Relief Act, by the way, that has changed considerably now, so you'll have to go back and look at the changes in the Specific Relief Act now. Under the old Specific Relief Act, it was necessary to plead and prove that a person was ready and willing to perform his obligations under the contract to the extent that he has not been prevented from doing so by anybody. It has changed now. It is enough to prove it. The new Specific Relief Act makes it sufficient to prove it. You do not necessarily have to plead it. So one of the big tragedies, if I may say so, of civil litigation was that the lawyer has forgotten to leave out the magic words ready and willing, and as a result of which he has not proved it, of course, because he didn't know that it was there. When he hasn't proved it, then necessarily specific relief would be denied. So today it is a little better. You can prove readiness and willingness even if you haven't pleaded it, but it is still necessary to prove it. Therefore, it should be in the pleading. So when they took away the necessity to plead and prove and said that it is enough to prove, they didn't make that big a difference. Because in order to prove something in a legal action, there has to be pleading. Without the pleading, it is difficult to prove something, or the court may stop you from proving it. So therefore, just assume that despite the change in the law, it is still necessary to plead and prove readiness and willingness. Now this is very important because if at all you are required to do a specific performance suit, it will involve pleading these aspects. Small digression. As I said, a river water dispute is the most likely suit that a lawyer will encounter in the Supreme Court. It will usually involve a contractual cause of action. A contractual cause of action that the two states have decided to share water in a particular ratio, and that one state is violating that clause in the contract. Normally, a contractual cause of action will definitely entitle somebody to damages and might entitle them to specific relief in the form of actual decree for water. Now, the next part is the prayer. And the prayer is one area in which we found the maximum deficiency in the answers which we received. Because there is a tendency of not understanding that there is a very specific prayer, there is a very specific language that has to be treated. Now you can only know that if you have practiced plains. Now, where do we get these from? The simplest source of any drafting of plains is the appendix to the Civil Procedure Code itself. It gives a whole series of plains. So even without going to any textbook, it is possible to learn how to plead or create a draft in most situations by looking at the appendix to the Civil Procedure Code. Beyond that, there are textbooks, which you might be familiar with. And beyond that, if you are confronted with a situation where you haven't found a precedent, then you would have to go step by step, marshal the facts, look at the cause of action, plead the cause of action, plead the prayer. This brings me now to a second aspect, which is an original petition. What is the time? No. Alright. So now, an original petition, as I said, the difference lies in the fact that evidence is to be pleaded in the original petition, and it follows from the fact that what ultimately is done is that you affirm, and therefore you create an affidavit out of it. The usual components of a petition is easier than a plaint, in the sense that you can just plead the facts one by one, chronologically, preferably, devote one paragraph to one subject. These are, by the way, these are guidelines given in the Commercial Courts Act. And as far as I am concerned, you should, when you're pleading facts, keep in mind the verification or affirmation that you're going to make. Now, why is this important? This is important because when you're pleading the fact, if you do not know how you're going to prove it, then it is ultimately useless. So, this affirmation will either say that this fact is true to the knowledge of a particular witness, or it will say that it is taken from a particular record. Keeping that in mind, you will decide whether this fact is capable of proof or not. So if you don't have a person who knows the fact true to knowledge, and if you don't have a document from which it can be said to be extracted, then there is no point in pleading that fact, because you are not going to be able to give evidence on it. Then, of course, there is a question of the legal propositions, the grounds, and these legal propositions are usually affirmed by saying that they are to the best of the knowledge of the person concerned and their belief that it is correct. So, submissions and statements are kept aside. Now, if that distinction is kept in mind while you are drafting the main body of the petition, then it becomes easier to affirm. And why do I say that it is difficult to affirm if you mix it all up? Then, in each sentence, there might be facts as well as submissions. If there is facts as well as submissions, how will you affirm that sentence? Then you will have to say that word so-and-so to word so-and-so is true to my knowledge, and word so-and-so to word so-and-so is my submission. That's very cumbersome. Instead of that, if one sentence is nothing but fact, then you will say that this paragraph is fact. If something is nothing but submission, then you will say paragraph such and such is a submission. Much easier to affirm. Affirmation is not an aspect which is tested that much in the examination itself, but I am not addressing you today merely from the point of view of the examination. But of course, if you can show that you understand the process of affirmation of a pleading, then you are going to, of course, be evaluated on a higher level than a person who has not shown his understanding of the affirmation process. By the way, to reaffirm what I have said in the beginning, show your knowledge, you don't have to demonstrate it chapter and verse. Just show it. So if you are not affirming the whole thing, if you just write one or two sentences by way of affirmation, you have given the examiner the idea that you understand that, and he or she will give you credit for that. Whereas if you don't, then nothing is to be done there. You will get what everybody else is getting. So then we come to the special leave petition or an appeal petition. Let me call it generally an appeal petition, because that will cover all kinds of appellate drafting which comes to this court. As I've already told you, you are at liberty to add the law and even judgments when you are reading the special leave petition. In other words, it can be argumentative. It can contain the argument. The parts of the civil procedure which says that all this should not be there in a pleading mostly relate to original pleadings, and so therefore it is possible in an appellate pleading to stretch the exercise and put in the main legal propositions. So the parts of an SLP, as most of you know because you've already worked in the area for some time, is the synopsis, the list of dates, the substantial questions, the grounds, the declarations, it may come in the beginning or in the end as the current practice is, and the prayers. Now you will be surprised how many of you in the heat of the moment will forget to do one of this list. And again I am saying, instead of making a long synopsis, give us 2 paragraphs, nothing more. You will get full marks for the synopsis. Give us a shorter list of dates. You don't have to give every date. Anyway, the question will not contain too many dates because we don't have the space to create a problem which is a long list of dates. So give us a list of dates. Give us the substantial question of law to show that you understand the distinction between a ground and a substantial question of law. A ground is enough for an appeal. A factual ground is enough for a first appeal. A legal ground is enough for a second appeal. But none of that is enough for a special leave petition or an appeal petition, because here there must be a substantial law of public importance. So some of the grounds has to transcend from being a mere ground to becoming such a ground as to raise a substantial question of law, important for the public interest. There is only one aspect which I shall come to in a minute. Let me finish with this substantial question of law. The substantial question of law, at least for the purpose of the examination, should not contain facts. It is not a substantial question of law if it relies upon facts. You can convert the fact into a legal proposition, make it abstract. Of course, there is a fact behind it, but if we make it abstract, then it becomes a question of law. Then it becomes applicable over a wide area. And so therefore, despite the kind of drafts which are filed in court and which our judges kindly overlook, which are not substantial questions of law at all, because it says that whether in the facts of this case this is correct or wrong, that's not a substantial question of law. In the examination, we will tend to be a little stricter than that, because you are expected to understand what substantial question of law means. And therefore, please confine yourself to a legal proposition and make sure that the legal proposition is at least something more than a mere legal proposition, that it is substantial question of law. Then comes the grounds. The grounds, there is a little more flexibility. Sometimes a little bit of facts can be pleaded in the grounds. It doesn't have to be a pure question of law. Now, I want to spend 2 minutes on the synopsis. I find that in most of the pleadings that we get and which are filed, subject to Justice Banerjee telling us her experience on this, the synopsis is often missing, or it is a synopsis of the facts alone. So having summarized the essential facts, then you go on to the list of dates, and that list of dates now becomes redundant because you already put it in the synopsis. So the synopsis has to be what? It has to be something over and above the facts, over and above the grounds. It must be something which focuses the attention of the court to the main aspect of the case. Our seniors say that if a synopsis exceeds 2 pages, it is ineffective. It has to, Mr. Palli Nariman says, it has to hit you between the eyes. Mr. Venugopal says that anything more than 2 pages is not worth the synopsis, then you've actually gone into the rest of the petition. So therefore, a synopsis is a must. It should focus the attention of the court on the main merits of the matter, and it must, in fact, I don't have time to go into that concept, it should give you a case theory. A case theory is that aspect of a case which you use to persuade the court. So this is how an appeal petition looks. And finally, what I will do is, very briefly in 2 minutes, give you a list of things which you can do to draft any petition which involves a judicial review. All our constitutional work is judicial review. The judiciary reviewing what? Either administrative decisions or legislation. That's it. There's nothing else in the writ jurisdiction. You either are doing judicial review of administrative decisions or doing judicial review of legislation. Now, when you're asking the court for judicial review of administrative action, first of all, the grounds would include, and you can choose as you go along, the administrative law principles, which usually are, number 1, abuse of discretion, and number 2, procedural impropriety, number 3, natural justice, which consists of 2 separate principles, audi alterum partem, that is to say, that it must, you have a hearing, and nemo judex, in re sua, which means that you must not be a judge in your own cause. Now, litigants often think natural justice is the same as justice. It's not. It's 2 very specific principles of administrative law. Abuse of discretion itself means that it's a discretionary power, so therefore you have to have something more than violation here. Because discretion, authorities which exercise discretion are not bound by specific rules. So when you are critiquing administrative discretion, then it is broken down into what is known as the 5 Wednesbury principles. Either a discretion has been fettering discretion. Number 2, the discretion has been delegated to a person who is not entitled to exercise that discretion. Number 3, the discretion is based on irrelevant considerations. Irrelevant. Number 4, relevant considerations have not been taken into consideration. And number 5 is the catch-all phrase, Wednesbury unreasonableness. That is to say, so unreasonable that no reasonable person, properly instructed in the law and fact, would ever consider it to be the correct decision. So, the Wednesbury principles are broken up into these 5. This helps you to critique a discretionary decision. Of course, if it is not a discretionary decision, then you can go to procedural impropriety, you can go to natural justice, etc. Now, in the Indian context, there are additional grounds to be taken for any administrative decision, and these are the constitutional grounds. It is unconstitutional if Article 14 is violated. There are 2 ways in which Article 14 can be violated. One is if it is discriminatory, and the other if it is arbitrary. The second ground of unconstitutionality is, of course, Article 19, which almost always involves being unreasonable. And then there is Article 21, and there can be other articles, but this more or less covers the gamut of things. Now, when we come to judicial review of legislation, it becomes more narrow. It can either happen because a fundamental right is violated, or if the legislative competence is absent. There is a lot of confusion as to whether any other part of the Constitution can give rise to judicial review proceedings. I will leave that for a completely different session. So, this is enough, according to me, to draft any writ petition and to draft any other proceedings where judicial review is being the subject matter of the appeal.
Says, when your facts are properly there, if you file a review, if you file a corrective petition, when you can rely on your synopsis to show that you had actually pleaded, you had made out a case which had not been considered by the judge. Once a special leave petition is admitted and it is numbered as an appeal and taken up, it is the same paper book which is used. So this synopsis that is made is used even at the appellate stage. Now there can be no two views of what has been emphasized by Mr. Gupta about the need to follow chronology. And I give a very childish example, which will just go in. If I were told to narrate my life history, and I started off with, I was born in 1957. I graduated in 1977. I went to school in 1962. You get all confused. From birth to graduation, then to her childhood, then to her. But when it comes in a chronological way, it goes in. It's logical. There is only one exception to that rule of chronology. When the matter comes to your knowledge at a later age, then perhaps you can first mention the date when you derived knowledge and then go back to the incident. Let us say, in narrating facts, on such and such date he entered an agreement. Let us say on 1st January 1922, the plaintiff entered into an agreement with the respondent. On 15th January, he made payment. On 16th January, something else happened. Then, on 4th February, he received a letter, and from that letter, he came to know that the respondent had earlier, in the previous year, entered into an agreement with somebody else. So that may make sense, because if you strictly follow chronology, and if you refer to the earlier agreement, then the question would be, if you knew about the earlier agreement, then why did you enter into an agreement at a later age? Now, so far as drafting is concerned, you improve with experience, you improve with habit. Unlike other papers where you just look up the law on a particular subject. You look up the provisions of the Constitution, you look at the Constitution cases. But in that way, drafting, it is vast because it covers different papers. It covers different statutes, different subjects. So whenever you start reading, you have to read the law. Look into the facts. In the case of an SNP, make a synopsis. Make your list of dates using the same principle of giving facts and material facts. Don't make it unnecessarily long that the court while reading it will lose track of the more relevant things. and then see that you have the grounds. If you want an interim relief, then there should be a separate prayer for interim relief. Otherwise, if you're fortunate to move it before a court which says doesn't matter, it's the lawyer's mistake, the litigant should not suffer, then it's fine. But if the court says, but where is your prayer? And where does your poor client go? You will then again have to make an amendment, add a prayer. It will delay matters. And when you make a prayer, you have to make out the grounds for the interim relief, which is granted. So these are the things in a nutshell. In a second appeal, you have to make out substantial grounds of law, substantial questions of law, if it is a second appeal. If it is an appeal under your Article 132, 133 or 134, you generally look at those articles. If the High Court has certified that a question of a constitutional question of importance is involved, then it's okay. The High Court will proceed, the Supreme Court will proceed with the appeal like any other appeal. In the case of a civil appeal, if the High Court certifies that there is a substantial question of law involved, then again the Supreme Court will hear it as an appeal. In the case of a criminal appeal, in some cases, admission is automatic. In what cases? I'm asking her. Only death sentence. Automatic admission. It's there in your constitution right there. If the High Court transfers proceedings to itself and then imposes death sentence, then admission is automatic. If the lower court grants an acquittal and there is a reversal and a death sentence, then the admission is automatic. In other cases, you may have to get it admitted. Please sit down. So these are the rules in a nutshell. I really don't have anything more to add, except that you have to hammer your point in the first paragraph. Don't make too many grounds. Have a few grounds. Have relevant grounds. Oh yes. And before I conclude, one advice which was given by our common senior, Mr. S. Pal, used to always say that if you have good facts, then the judge will try to twist the law in your favor. If you have bad facts, the judge will try to hold against you. So if your facts are good, then emphasize on that in the somewhere in the synopsis and show how unjust the order is. Perhaps you would get the relief in that case. Thank you very much. It's always a pleasure to be amidst you.